It is a subject most of us instinctively avoid. We build our lives, gather our loved ones, and fill our homes with memories, hoping the time to say goodbye is always somewhere far in the future. But the reality of death is inevitable, and it brings with it an often overlooked burden.
When a loved one passes away without a legally binding will, the grieving family is left to navigate a complex, rigid legal framework known as intestacy. Regardless of your personal wishes or unique family dynamics, the state steps in to decide how your life's work and assets are divided. Today, we will explore exactly what happens when someone dies intestate and why leaving your final wishes unspoken can change your family's future forever. So, what exactly does it mean to die without a will? In the legal world, this is known as dying intestate. It simply means passing away without a valid legal document detailing how your property should be distributed. It is a very common situation, but it drastically changes what happens next. When this happens, a complex web of default rules takes over, acting like a legal maze. Because you did not leave instructions, your state steps in with its own default framework, known as intestacy laws. These laws decide exactly who gets your family home and life savings. A common myth is that the government immediately seizes your assets. In reality, probate courts and appointed attorneys must untangle your estate using strict state formulas. These rigid rules prioritize spouses and blood relatives, completely ignoring unmarried partners, close friends, or your favorite charities. When you pass away without a valid will, you die intestate. In this scenario, you no longer have a say in who inherits your hard-earned assets. Instead, the state steps in to make those decisions for you. Because intestacy laws vary from state to state, how your assets are divided depends entirely on where you lived at the time of your death. To manage this, your estate enters the probate system. A local probate court appoints an administrator to settle debts and distribute property, aiming for legal fairness. But this is a rigid, inflexible system based entirely on the books. The court follows a strict hierarchy of inheritance. First in line is almost always your surviving spouse. Next are your children, who often split the estate with the spouse. If you have no spouse or children, the state looks up the family tree to your parents. If your parents have passed, the assets flow out to your siblings. This predictable formula continues down the line to nieces, nephews, and even distant cousins. But because it relies on strict legal definitions, it completely ignores the nuances of modern blended families, unmarried partners, or close friends who meant the world to you. When the state decides, it only recognizes legal relatives. To see how intestacy laws actually play out, let's look at a few common scenarios. What happens if you pass away, leaving behind a spouse and children? In many jurisdictions, the surviving spouse doesn't automatically inherit everything. Typically, the estate is divided between your spouse and your children. A common formula gives the spouse an initial lump sum plus half of the remaining balance, with the children splitting the rest evenly. Now, consider a scenario where someone passes away, leaving a spouse but no children or descendants. You might assume the spouse takes it all, and in many states they do. However, in some jurisdictions, if the deceased person's parents are still alive, the surviving spouse might have to share a portion of the estate with their in-laws. What if there is no surviving spouse, but there are children? In this case, intestacy laws are generally straightforward. The entire estate is divided equally among the deceased person's biological and adopted children. If a child has already passed away, their share typically passes down to their own children, meaning the grandchildren step into their parents' shoes. Finally, what happens if someone dies without a spouse, children, or surviving parents? The law looks for the next of kin. The search expands outward to siblings, then nieces and nephews, grandparents, and aunts or uncles. If absolutely no blood relatives can be found, which is extremely rare, the estate escheats, meaning the assets legally become the property of the state. While intestacy laws dictate the distribution of many assets when someone dies without a will, it is crucial to understand that not everything is subject to these rules. Certain types of property bypass the probate process entirely. First is jointly owned property. If you own a home, a bank account, or other assets jointly with someone else, and the agreement includes the right of survivorship, the surviving owner automatically inherits full ownership. The intestacy laws do not apply here. Life insurance policies and retirement accounts, such as your 401k or IRA, also fall outside of intestacy. Because these accounts require you to name a specific beneficiary when you set them up, the funds will go directly to the person you designated, regardless of what the state laws say. Finally, any assets held within a living trust are exempt. A trust is a separate legal entity, so the assets inside it are distributed according to the specific terms of the trust document, completely avoiding the state intestacy process. Dying without a will doesn't just leave your assets in the hands of the state. It leaves a heavy, unseen burden on the people you love the most. Without clear instructions, family members are often forced into stressful, emotionally draining disputes over who gets what. The legal process, known as probate, becomes significantly more complicated. Your loved ones can face agonizing delays, waiting months or even years to access funds they might desperately need to cover immediate expenses. Then there's the risk of unintended beneficiaries. Because state intestacy laws follow rigid formulas, your hard-earned assets could end up going to a distant relative you've never even met, instead of a close friend or unmarried partner. And finally, the financial toll. Intestacy often triggers higher legal costs and court fees, slowly draining the estate. It's a heavy price to pay, but one that is entirely preventable with a little advanced planning. While the rules of intestacy might seem daunting, the good news is that avoiding them is entirely in your hands. Taking the time to create a clear estate plan is one of the most empowering steps you can take for yourself and your loved ones. By drafting a will, you replace state-mandated formulas with your own personal choices. You get to decide exactly who inherits your assets, and more importantly, you can name a trusted guardian to protect and care for your minor children. Beyond distributing wealth, a well-crafted estate plan eases the emotional and financial burden on your family during an already difficult time. Instead of leaving them to navigate a stressful legal maze, you provide them with a clear, straightforward path forward. Don't leave your family's well-being up to the default laws of your state. Consult with a qualified legal professional today to draft your will and secure your legacy. Thank you for watching our guide on intestacy laws. While thinking about the end of life is never easy, having a clear plan in place is the best way to protect your loved ones. Don't leave their future to state formulas. Take proactive steps today to secure their peace of mind. If you found this video helpful, please give it a thumbs up, leave a comment with your thoughts, and subscribe to our channel for more valuable insights. For additional resources and to help you plan for the future, visit us at funeralists.com. Thank you for watching, and we will see you next time.